and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everyone to this Monday, January 31st, 2011 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. Tonight's Monday night, and this is the Trust Ambassador call, so let's open up for Q&A and invite the Trust Ambassadors on. Eric, are you there?
Hello, good afternoon, good evening.
Hi, Marshall.
How you doing, Christian?
Good. How are you doing?
I'm all right. I'm okay. Everything's great.
Eric, can we find Eric?
Q&A session started.
Hey, Christian.
Hi, Eric. Hi.
Hey, I was having a little bit of time getting on. A little bit of a hard time getting on. I don't know what happened. Hey, Marshall.
How you doing, sir? How you doing today? All right.
Good to hear your voice. You too, Christian. Hello, everyone. Today it is January 31st, 2011. And it's you and I, Marshall, it looks like. And have you been looking at the Maxims and Henry Gibson's book at all? Have you had a chance to review those at all?
Yeah, actually, I started reading them today, as a matter of fact.
Well, what I found is pretty interesting is he's given us a different way to look at some of this stuff, even though it's kind of the same as what we're used to seeing. It's still kind of different. Have you noticed that?
I like his explanations of things better. I think he explains the maxims and the practical application of how they would be used better than, say, any other book that I've read as far as the maxims are concerned. I just like the way he puts the maxims together here.
I completely agree. He's done a wonderful job. And I didn't have much of a chance to read through a lot of them, but in what I did get the chance to read, I like the way he also titles them as well. So for those of you out there that have been listening on Mondays and listening to the maxims and getting a better and better idea of how they apply, and the fact that everything in law and in the statutes, everything's based upon them. Hopefully, as we discuss this more, that you'll get a better idea of where everything actually evolved from, and that in fact is from equity. And is there any particular maxim that you saw that you'd like to start with? Because I mean, I can start with section 31 of the book and be just fine with maxims generally considered, and then we can actually talk about them. But I thought that this might be a great place to begin in order to bring it into the frame of how Henry Gibson looked at it. And if you're okay with that, then I'll go ahead and announce where we're at, and for everybody to know where we're at, Marshall.
That's fine with me.
All right, everyone tonight.
Start in the beginning.
All right, everyone tonight, we're going to discuss the Maxim chapter in a treatise on suits and chancery by Henry Gibson. If you don't have a link for the book, please ask on Welcome NTT for the link. If you're not a part of the Welcome chat group, the Welcome NTT chat group, please contact Faith, that's number 2, and then the word trust on Skype in order to be added to our chat group, in order to get a link for this book, and to be a part of our community here at New Trust Technology. And also, for those of you who are new on the call, the best way that you can possibly learn what it is that we're doing here at NTT is to become a transcriptionist and transcribe these calls, because then that actually forces you to work with the material and look up terms you don't know, and go back on calls in order to get a better understanding of what we're talking about today. And for those of you that are new to the calls, please don't let our context of discussion dissuade you. We've been at this for more than a year now, since November of 2009, and we've all gone through quite the fast track of the opportunity to learn. And for those of you who've been with us this long, thanks for hanging around, and I'm glad that you have. I'm sure you're glad you have. And for those of you that are new, go back to the calls that began in November 2009 in order to get up to speed. In beginning and opening the calls, is there anything else you'd like to add, Marshall?
No, not at this time.
All right, great. To recap, over the last few months of what we've actually talked about, we went through Corpus Juris Secundum and went through the Maxims in that book, and then we referenced Snell's book, and then also, what was the other book we referenced from time to time? I'm trying to think of the author. Was it Wheaton or Carlin? Some of those other authors I know we've referenced in some of the books, but mainly Snell because he went into cases as far as the books.
I've noticed that Gibson's, he makes a lot of references to Pomeroy's. If you really look into the footnotes, you see a lot about Pomeroy's in there, and that's actually something that I was doing today when the footnotes actually referred you to the Pomeroy section. I would go and read the Pomeroy section, and it would just add more information to it. So definitely want to recommend that. Yes.
Hey, is my voice real clear to you?
Yeah, very.
All right. Well, yours is breaking up quite a bit. I don't know if it's breaking up for everybody else. Let us know on the welcome chat if he's clear or if he's breaking up, because if so, you might have to reset your modem in order to have a good, clear connection. But we'll know in a moment. I'm sure everybody will let us know.
Okay, I'm seeing on the Skype that there's some people having some problems with getting in on the free conference, and so maybe that's it.
Okay. Yeah, I had quite a few.
Am I still sounding choppy?
Yeah, let's give it a minute, and then if you do, I'll have you reset.
Okay.
Okay. Bruce says you sound okay. A bunch of people are having a hard time getting on. So keep trying, everybody. I had to try straight for about 5 minutes myself, so don't let it discourage you. All right, they'll get on. You know they want to hear it, so they'll be on in a minute. Let's see if you approve in a minute, and if not, then I'll let you know, Marshall. All right. Okay. Reading section 31, which is page 52 of a treatise on suits and equity by Henry Gibson. Section 31, page 52 of the PDF, page 25 of the book. Okay. Section 31, Maxims generally considered. There are certain great underlying principles, often called maxims. And then we'll go to the footnote 1 after I get done with all the footnotes, actually, after I get done with the paragraph. Footnote 1, which are the fruitful sources of a vast number of particular rules containing both rights and remedies. These principles are a component part of equity jurisprudence. They lie at the foundation of universal justice, are the sources of municipal law, and have been worthily and aptly called legum legis, the laws of the laws. These maxims are, in the strictest sense, the principia, the beginning out of which has been developed the entire system of equity jurisprudence by a process of natural evolution. The student who has made these principles a part of his mental habit, who has, as it were, incorporated them into the very intellectual being, has already mastered the essence of equity, and has made the acquisition of its particular rules an easy task. Boy, they sure didn't say that in CJS, did they, Marshall?
No, that's what I'll tell you. I like the I like Gibson's way of explaining it a lot better. Not to take anything away from CJS, but I just like the way this guy he put things together, and a little bit later we may be able to talk about. I've actually found history, although this book is based out of Tennessee. I found out something very, very interesting as far as my state of North Carolina and Tennessee, and why this book actually speaks a lot about North Carolina in a particular section. But we can get into all of that later. It's just more reasons of why I love this book.
Hey, Marshall, you're
Yes.
breaking up pretty bad. You want to try to reset?
Okay, give me a second.
All right. You'll be back on in a minute. You might have to turn your modem off and reset it, maybe.
All right.
All right, I'll see you back here in a minute. I'll get started in the footnotes reading. Oh, crap. All right. Footnote number 1, Maxim, the dicta quia maxim, et jus dignitae et auctoritas, accu quod maxim omnibus probator. And that's my best attempt at Latin, so please bear with me, folks. A maxim is so called because its dignity is maximum, and its authority the most certain, and because approved at the maximum by all. The second footnote in that first paragraph is out of a book by the name of Kent, and so fundamental are these maxims that he disputes their authority is regarded as beyond the reach of reason. Koch says maxims of law are holden for the law, and Bacon says they are the fountain of justice from which flow all civil laws. Maxims, this is by Beard, have their foundation in universal law. They are embodied in the common law and are essential part of its warp and woof. And that was footnote 3. And then footnote 4 is a Latin term, principia probas non probantur. Maxims are proof and need no proving. Everybody remember that footnote 4 out of section 31. That is key to how we will express ourselves and express our trust based on the maxims. That maxims are proof and need no proving. And then the 5th footnote is out of Pomeroy's Equity Jurisprudence, sections 121 and 360. So vast is the number and variety of suits in chancery that it is impossible for a solicitor to find a precedent for every case, even if it existed. But he who has the maxims mastered is saved much of the drudgery of hunting precedents. Out of the 26 letters of the alphabet, by permutations and combinations are made the countless multitudes of words and sentences written by earth's millions since writing was invented. So out of a few fundamental maxims can be deduced the rules which, by proper application, will determine the equities of the vast proportion of equitable suits instituted in chancery. And then there's more Latin, which I'm not going to attempt, but it says, it is better to seek the fountains, the maxims of the law, than to follow the rivers, hunt for adjudications based on maxims. So just based on that statement right there, now everybody knows why we're still talking about the maxims after a couple of months, 3 months now, because it's that important. And in order to better understand what it means to seek the fountains, then follow the rivers, the fountains being the fountains, based on what was talked about by Bouvier about that equity is the law, and law is nothing without equity, and the statutes are nothing without law. So better to understand the foundation of it all than to go seeking anything that has evolved from the foundation in order to know that really is the fountain. The maxims and principles contained in this chapter are not all strictly maxims and principles of equity. Many of them are maxims and principles of the common law. Nevertheless, they have all been adopted into the family of equitable doctrines and are constantly used and applied by our chancery courts. The author has long been convinced that no one can master the jurisprudence of equity who has not been thoroughly comprehended to subtle alchemy in its maxims, whereby the most difficult problems are readily solved. And so, believing, no little space has been devoted to them. These principles and maxims constitute a system of jurisprudence based on good reason and good conscience, and are designed to enable the courts of equity to do complete justice between all of the parties in any litigation, however novel, abstruse, complicated, or numerous the questions may be. Stand by because I have a few messages that I have to read in order to proceed on with with what's here in the book. I think I might take just a moment and see if I can bring Marshall in through Skype here and add him to the call. So stand by, everyone, please. I got a new Skype, so please stand by. You might not be able to do that with the Skype that's in Linux. So is that better? Sorry, everyone, for the delay. Maybe that's a little better. So you're telling me that I'm too loud on the call? Oh, just Skype, please. Okay. All right, good. I can leave it like that. All right, still trying to get Marshall back on the call, everyone. Still waiting on Marshall. Stand by, everyone. Sorry for the delay. All right. Still waiting on you, Marshall. I know. He's probably still trying to get on. Yeah, I'm on the call. Can you hear me? All right. So I'll wait for a response from these guys, and I'll read on in Section 32, Equity Acts upon the Person. On page 26 of the book, it's going to be 53 of the PDF, everyone. When the chancellors first began to exercise judicial functions, they refrained from using common law or statutory processes, probably to avoid conflicts with the common law courts, which were jealous of the extraordinary powers exercised by the Chancery Court. Instead of commanding the sheriff to take the money, decreed the complainant out of the defendant's property, the chancellor commanded the defendant to pay the money. 2, instead of empowering the master to divest title to land out of the defendant, invest in the complainant or the purchaser, the chancellor required the defendant to execute a deed to the complainant or the purchaser. 3, instead of forbidding a court of law to proceed in a suit or to enforce its judgment in a given case, the chancellor forbade the plaintiff from proceeding in the suit or doing any act towards obtaining an execution. And 4, in the general decrees of the Chancery Court were enforced through the personal act of the party himself. Footnote 7. Footnote 7 refers to primary equity jurisprudence, section 428. So make it a point to go and follow up on these footnotes and read these sections in the context of what Henry Gibson wrote about here. Reading on in section 32, if the party failed or refused to do what the chancellor by his decree required him to do, compulsory process was issued, but no compulsory process was issued until the party had been served with a mandate commanding him to do what the court required of him. Footnote 8. See Dan, Chancery Practice, section 1043. Back to the text. If he then disobeyed, he was adjudged in contempt and was committed to prison until he complied with the orders of the court. If he still refused, his property, real and personal, was sequestered and applied to the satisfaction of the decree. So for those who are failing or repudiating because they don't understand, or not repudiating, but refusing to express trust and letting them repudiate the trust because you're the trustee, and they find you in a debtor-creditor contract, and then you get sent to jail. Well, that's why, because if you still refuse, your property, real and personal, your personal property yourself, will be sequestered and applied to the satisfaction of the decree. This was formerly the practice in North Carolina and Tennessee, but in 1787, in consequence of the then mode of carrying into effect the decrees of the Court of Equity by attachments, habeas corpus, attachments by proclamation, and commission of the rebellion being in many cases dilatory, oppressive, and inadequate, the legislature of North Carolina authorized executions to issue the Chancery Decree as at law. And in 1801, the legislature of Tennessee enacted that instead of decreeing parties to convey lands as theretofore practiced in equity, the court was given the power by decree to divest the title out of the person against whom the decree was pronounced. Footnote 9. See chapter in the Enforcement and Decrees. And I take it they're probably referring to the chapter on enforcement of decrees in this book, in Henry Gibson's book here. Reading on in the text, in section 32, page 53 of Henry Gibson's Treatise in Suits and Chancery, since the passage of these two acts, our courts of Chancery have not acted ordinarily in personam. Since the passage, these two acts. They have not acted in personam. Wow. The vast majority of chancery decrees are now enforced by executions, attachments of property, writs of possession, divestiture of title, and orders of sale. So that it may now be said that our courts of chancery do not act ordinarily in personam. Nevertheless, the maxim that courts of equity operate in the person is true, and most important results follow from the maxim. And although in practice our chancery court acts ordinarily on the property of the party, yet it has all of its original authority to act on the person of the property, as will be seen by inspecting the code 4478 through 4488, and it will be more fully shown hereafter. Footnote 10, see chapter on the enforcement of decrees, but I thought that was earlier. Maybe footnote 9 was, see Scott's book. Oh, that's what it was. Footnote 9 was Scott's book in sections 389 and 692. If I got that right, that print's awful small. And we can continue along with everybody that was on the call. Continuing on in section 32, I was under number 1. Okay, that was on page 53 of the PDF and 26 of the book. So if you'll follow along, it's section 32, number 1, under section 32, towards the bottom of the page, where the parties reside within the jurisdiction of the court, but the land or the subject matter is a controversy is not. In such case, if equity so require, the court may, by attachment, compel one party to convey the land to the other. And that's footnote 11, and that's Miller v. Birdsong. And it says, it is not that a subpoena to answer was served on the defendant. He must be an actual resident within the territorial jurisdiction court. Back to the text, hence a specific performance will be decreed as to the land in a foreign country. So a trust will be declared and enforced, or a mortgage foreclosed or redeemed, or a fraudulent judgment overhauled, and even the sales under such a judgment when the lands or the judgment are in a foreign country. Footnote 12 says, under Story's equity jurisprudence, section 1291 through 1294, in general, the fact that the property is not within the jurisdiction constitutes no bar to a proceeding in a court of equity. If the person is within the jurisdiction for a court of equity, acts upon the person. Or, to use the appropriate phrase, equitas agit in personam, but questions may arise under a bill respecting funds or other things in a foreign country, so purely local that a court of equity in another country might be very properly declined to interfere, and remit it to the domestic forum. The domestic forum, that must be the at-law side instead of equity. And then that's under Story's equity 489. See also Johnson versus Kimbrough, head 6557. All right, reading on in the text, but where in order to give relief, the relief is sought, it is necessary to deal directly with the land itself. Without the agency of the parties, then the fact that the land is outside of the jurisdiction of the court would debar the court from granting the relief, because the court will not make a decree that it cannot enforce by its own authority. Footnote 12. The decree of a judge who undertakes to exercise jurisdiction beyond his state may be disobeyed without punishment. I'm trying to find my place in the text. Thus, a bill cannot be brought for a partition of land outside of the jurisdiction, for the court cannot send commissioners there, but a bill may be maintained for rent and profits of land outside jurisdiction. Footnote 14, see Story's equity jurisprudence, section 1292 through 1300. Number 2 under this section is for a discovery of facts or a property. Footnote 15, or the delivery of documents or the surrender of personal property or trust funds is commanded. So footnote 15 says, see the Tennessee Code 4283 through 4285 and 16 says, on the jurisdiction of the Chancery Court to act in personam, see Pomeroy's equity jurisprudence, section 135, 170, 1317, and 1318. So the maxim still is alive. Make no mistake about it. But the reason why the court started acting on the property and divesting people of title is because the system of commerce came to play there, opposed to things being purely relation among men. So because that became an apparent factor within the relation to people, the court was able to take control of the titles instead of and able to split them and then able to act on behalf of that. But the only way the court would otherwise be able to act and order people to do stuff is we have the right to the title opposed to duties therewith. And then that way we can get those groups carried through and get those people to actually form and get equity to act persona. That's the evolution of where it's gone to and where we need it to go to. Reading on in section 33, which is page 54 of the PDF, which is page 27 of the book, equity will not suffer a wrong. Equity will not suffer a wrong without remedy. This maxim and the maxim that equity operates upon the person are two of the principles most active in originating and molding the chancery jurisprudence. The king, as the fountain of justice, with an oath resting upon his conscience, to see that right was done, all his subjects. Footnote 17. The Constitution of our state, which may be called our fountain of justice, provides that every man, for an injury done him in his land's goods, person, or reputation, shall have remedy by due course of law, and right and justice administered without fail. Right and justice administered without fail. Denial or delay. Constitution of Tennessee, Article 1, Section 17 says, for every injury the Constitution declares there shall be a remedy, and the Chancery Court has had, from its foundation, the inherent right to provide or adopt a remedy for any case of injury, wherefore no remedy clearly appears. So that splits the Chancery Court and the outlaw side when I'm looking at that, because there in the outlaw side we see the remedy, in the Chancery Court it says it has the inherent right to provide and adopt a remedy for any case of injury, wherefore no remedy clearly appears. It's the Pomeroy's Equity Jurisprudence, Section 1, 21, and 29. Bishop's, and I don't know the title of that book, so you have to forgive me, but it says PR Equity, so it's I'm sure it's something of equity. Section 6 and 7 is Story's Equity Jurisprudence, Section 39 through 44. So I'm going to be looking up the author of Bishop and looking up what the titles of the books are, and I suggest everybody do that so we can all get a speed as we're learning as we're going through this. Reading on in the text, to catch the context of that, the king, as the fountain of justice, with an oath resting upon his conscience to see that right was done to all his subjects, and believing that he has the prerogative power as the supreme judge of England to do whatsoever he deemed was right and just as between man and man, without reference to laws, customs, statute, precedents, or courts, and prompted no doubt by his ecclesiastical chancellors, and was not willing to see a wrong done to a subject, and to be told that there was no power in his kingdom to right that wrong, that the common law furnished no remedy therefore, and that as a consequence, the wrongdoer in that particular was superior to law, and mightier than the king. And when I read that, there's only one possible way that can be, and that's based on what's truly in conscience, which is what the court of equity is. It's a court of conscience, knowing what's right. Reading on in the text, hence was it that the king, deeming such a state of fact derogatory to himself, disparaging to his prerogative, disgraceful to his kingdom, and dereliction of duty under his oath, took personal cognizance of such matters when petitioned to do so. And when petitions became too numerous for his personal attention, he referred them to his chancellors, who were the keepers of his conscience, with authority to do whatever good conscience, good reason required in the premises. The common law had a maxim, ubi just ibi remedium, wherever there is a right, there is a remedy for the violation of that right, but the maxim was too general to be true. Had it been true, there would have been no need for a chancery court. To support this maxim, it was held that if there was no remedy, then there was no right, which was the same as saying that the right depended on the remedy. And unfortunately for the common law, this was true. For under the common law, every cause of action had to be adopted to someone under its technical and arbitrary forms of suit, and this could not be done. Then the suit could not be brought, so that at common law, the right had to be adapted to remedy, thus violating at the same time both reason and justice. In the Chancery Court, the opposite was adopted and enforced. The remedy was adopted. The right thus made to assume any form the right required. Hey, folks, I'm going to take a break for a moment, and I'm going to see if I can bring Marshall in on Skype, and then he can have discussion, and you guys can listen to Marshall and I actually talk about this stuff. Things might work out pretty good now that I'm thinking about it. Looks like Marshall's not answering. Perhaps we'll be able to get him on in a little while. So, reading on in the text, the maxim, or as it is sometimes expressed, equity will not suffer a right to be without a remedy, is the original source of the entire equitable jurisdiction of the Chancery Court. I'm going to read that again. So this maxim, or as it is sometimes expressed, equity will not suffer a right to be without a remedy, is the original source of the entire jurisdiction of the Chancery Court, exclusive, concurrent, and auxiliary. And a full explanation of the scope and meaning of this maxim would require a discussion of the whole system of equity. Footnote 18. Footnote 18 says, stand by, I lost my place. Footnote 18 references Cromwell's equity jurisprudence, section 423. And now that the jurisdiction of the Chancery Court has been so greatly enlarged by statute in Tennessee, the force of the maxim and its beneficence, I hope I'm saying that right, have been proportionately enlarged. The wrong that equity will not suffer to be without a remedy must be a civil injury to the complainant's rights or interests, legal or equitable. There are some duties equity does not attempt judicially to enforce, such as charity, gratitude, and kindness, and some wrongs with which equity does not interfere, such as violations of honor, or of truth, or of morals, involving no question of property and no question of pecuniary liability. But any wrong done to a legal or equitable right will be redressed in equity unless some other court has exclusive jurisdiction. And of course, when we apply the doctrine of NTT, we know that if we express trust, there will be no other court that has exclusive jurisdiction, because the only way that we're going to be able to get our rights enforced is in a court of chancery. But of course, that can only be done by having the record and utilizing the maxim as our proof. This maxim was originally intended being that in all civil cases within the scope of judicial action where a wrong had been done or was threatened to be done, and a full, complete, adequate, and certain remedy could not be had in the common law courts, a remedy would be provided and enforced in the Chancery Court, and all jurisdiction assumed necessary for that purpose. And in order to enable the court to adequately exercise this jurisdiction and to make its remedies effective without coming into conflict without the powers or possibilities of common law courts, the plan was devised of compelling the defendant himself to execute the decree of the Court of Chancery by imprisoning him, if necessary, until he did so. Hence, the maxim, equity acts upon the person, and it might be said that on these two maxims hang all equity. Wow, that really says a lot about the way our legal system is acting today, that paragraph right there, about how the plan was devised of compelling the defendant himself to execute the decree of the Court of Chancery by imprisoning him, if necessary, until he did so. In pursuance of these two maxims, the Court of Chancery has devised or adopted from the Roman or civil law the following remedies, none of which existed in common law. Number one, specific performance of contracts. Two, injunctions to restrain the violations of rights to say unjust proceedings at law, to stay unjust proceedings at law. To quiet title and to prevent wrong. Three, the re-execution of instruments lost or destroyed. Four, the reformation of deeds or contracts erroneously drawn by accident or mistake. Five, the rescission and cancellation of agreements and conveyances obtained under circumstances of surprise, fraud, or mistake. Six, the reopening of settlements and adjudication of complicated accounts. Seven, the method of winding up all the affairs of a partnership. Seven, the marshaling of securities. Maybe that's why the marshal comes out to get us when we run from the law. They have to marshal the surety for the security when people run and they come out to hunt you down. Very interesting term right there. 9, the redemption and foreclosure of mortgages. 10, the partition of land between tenants and commons. enforcement of trust and fiduciary obligations. 12, the exoneration, contribution, and subrogation of estate of insolvent debtors and insolvent corporations. 15, the enforcement of liens. 16, the protection of the person and estates of infants. The establishment of a wife's equity. 17, 18, the remedy by interpleader. 19, the perpetuation of testimony. And 20, a discovery in aid of legal proceedings. So when you're dealing with a cat-law side of the case, there's all these things that have evolved from equity and in order to make things fair on both sides. When you look at this list of things right here, in order to understand how things can become fair and the kind of things that get implemented, this list of 20 things is so important to be able to recognize and see as you're dealing with a court case or you're watching a court case proceed, the kind of things that people are using that actually are equitable that have been brought into the outlaw side. So if we are able to understand the context that all the statutes are based on equity, and law is nothing without equity, that we're going to be able to see how things have evolved, and that's where we need to go back to in order to do complete justice. So otherwise we leave half of the opportunity for justice on the table and miss out on the other part, which is our private relief in equity, and which the equitable side, the private side, can only go into the public side and do complete justice. It can never be from the opposite. You can never do anything from that fictional side in the real realm. You can only go from the real realm and affect things in the fictional side. So as long as we continue to let them repudiate in the outlaw side, because we don't have the records and we don't take the maxims in and understand what it is that we need to do in order to express trust, then we'll always be deficient in seeing a decree being enforced in our situation, so we can get complete justice. So with this, with all these things that we're learning about, it is so important for us to do complete justice and to invoke equity by the way that we're putting our bills together and the elements that are in our bills, putting a proper bill together. Study this book, go into this trust section in the back in the index, and learn about all these sections. So that way, when we have the opportunity for some discussion on some call, you'll have some stuff to discuss with us trust ambassadors or with Christian or just amongst yourselves in order to better affect what we're doing here at New Trust Technology. Reading on in the text in section 33, thus upon these two maxims, equity will not suffer a wrong to be without a remedy, and equity operates upon the person. Was builded as the grand structure of jurisprudence called equity, and although by means of the improvements in the process of the courts, aided largely by wise legislation, remedies for every civil wrong known to courts have been devised and enforced. If in the progress of civil execution, if in the complicated network of mercantile business, if through the ingenuity and subtlety of the human mind, bent on what schemes of personal or pecuniary advantages or intent on devices for aggrandizement, new remedies should be required to circumvent circumvention and to overcome the insidiousness of any sort of Machiavellism. The Court of Chancery, operating in obedience to the maxim, will devise a remedy adequate to the emergence and vindicate the beneficence and capacity of its inherent powers to do justice in any case, and to right every wrong, however intricate the case, however great the wrong, or however powerful the wrongdoer. Footnote 15. Chancery has been handmaid of all courts to affording process to meet exigence. She has done so in the face of tyranny to break loose the iron hand of power when grasping against conscience. Before the establishment of the Chancery Court in England, it might have been often said, de legibus non currant maximus. The powers that lie dormant, back to the text in section 33, the powers that lie dormant in this potent maxim will awaken as the necessities for their actions arise, and they will be found commensurate with every necessity. It must not be forgotten, however, that this remedy may be forfeited or lost by the party wronged, forfeited, number one, by some fraudulent, illegal, or unconscious conduct in connection with the wrong he complains of,
whereby his hands had become stained with inequity. Or 2, by having, through his fault or negligence occasioned or contributed to the loss complained of. For when one of the two persons must suffer, the loss must be borne by him whose act caused it. Footnote 20. See Stories Equity Jurisprudence, Section 387. Or the remedy may be lost. 1, by the fact that adverse party has an equal or superior equity, or 2, by laches or acquiescence, or 3, by subsequent contract or estoppel. So, you got to act in order to express your rights, and you got to have the records to show that you have a superior equity or an equity at all, because we know when they come out of that law, they don't have any equity. All they're doing is just repudiating and giving us the trustee title, because we don't show that we're sovereign enough to have any equity. And if we're silent, then we're sleeping on our rights. And, of course, if we wait to speak up on our rights, then it's determined to be acquiesced or silent. And then also, if they come with some action that stops us from expressing our rights as we fail to, for example, sleeping on them, based on number 3, then that would be a contract that would step in that we would have a duty to deal with. So we have a lot of things to consider in order to not forfeit or and lose. Number 34, Section 34 on page 55, equity acts typically and not by way of compensation. This is 55 of the PDF and 29 of the book. And this is followed up by footnote 20A, and it says Snell's book, and that's section 47. And I'm trying to remember the title of that book right now. And the Snell's PR. So I'm not positive what PR means. So if somebody wants to share that with us on Welcome NTT, and we can have an idea of what that actually means, and I'll have a better understanding of it. And before I get into 34, I'm just going to take a quick break, see if I can get Marshall back on standby. Hey, everyone. I have Marshall on the line with me, so say hello, everyone. Marshall?
Hello, everyone.
All right. And, Marshall, I was about to begin Section 34 on page 55, the PDF.
Section 34, page 55 of the PDF.
All right. So I took a break just before I got into the text of that. So let me know when you're there.
I'm there.
All right. And just before we begin, obviously you were having quite a bit of trouble because I see free conferencing was down. I was not able to get on it either.
Yeah, this thing was giving me all kinds of problems.
And me as well. So if anybody's having trouble, we certainly understand. So if anybody can dial in or needs the number to dial in, 712-432-0075. Matter of fact, maybe let me post that real quick on the welcome group. All right. Equity acts specifically and not by way of compensation. This principle runs through the whole system of chancery jurisprudence. Equity aims at putting the parties exactly in the position they ought to occupy, giving them in specie what they are entitled to enjoy, and putting a stop to injuries which are being afflicted. Thus, equity decrees the specific performance of a contract instead of giving damages for its breach. So equity restrains the commission of a trespass instead of compensating the aggrieved party by damages. In some cases, also, a party will be compelled to specifically make good his representation by which another has been misled. Footnote 21. And that's Fitchman's book, and I'm not sure what PR means, if you know what it means, Marshall. All right. Well, as I said a few minutes ago, maybe somebody can let us know on the welcome chat what the actual title of that book is so we can stop calling PR and equity, because we know we're equity jurisprudence. But maybe somebody will share that with us as we continue through the read. So equity will declare a person who has knowingly acquired trust property a trustee, and will make property purchased in his own name by a fiduciary with trust funds, trust property. Equity will construe and enforce wills and other express trusts, and will set up lost or destroyed instruments and records, and will cancel fraudulent deeds and remove clouds on title, and will, by injunction, protect a party in its right, or restrain a party in its wrong. In all the foregoing cases, the common law either gave no remedy or else merely allowed damages for the wrong the latter remedy, when allowed, being often wholly inadequate and sometimes from the poverty of the defendant, wholly worthless. So, Marshall, you know what I'm thinking about as I'm reading through that?
No, I don't.
I'm thinking about when we sit down at the closing table and we hand over that note, and that's our equitable title. Well, even if they never, ever produce the note, because we know it was produced, because I can testify, I can give records that it was produced. Well, equity is going to, whether you have the note or not, they're still going to go ahead and declare that, what's that say? The first suit
has only acquired trust property, a trustee.
They're going to declare that person a trustee, and they're going to make the property purchased in his own name a fiduciary with trust funds. So they're going to make that trustee a fiduciary. Trust property will construe and enforce wills and other express trusts.
If you remember, Eric, this is exactly the rules, or I should say the maxim, that was applied in the Maxims Center in Hutchinson case. Exactly what they used against him, because remember in that case it was about stolen cash or stolen money that was used to buy or purchase a vehicle, and there were two methods of relief or cause of action and trust that the Maxims Center was able to choose, and this is exactly the specific one that they used against him, where they were stating that if being that you stole the money from us, which was Maxims Center, and you bought the vehicle in your name, then it will be construed to you buying a vehicle having the legal title in your name, and being that you bought this vehicle with the property of the trust or the cash from the trust or the trust res, then it will automatically be thought of you purchasing this vehicle for the beneficiary. And that's exactly what they did. They enforced this actual this maxim here.
So
we will declare a person who has knowingly acquired trust property a trustee, and will make the property purchased in his own name, which is the legal title, by a fiduciary with trust funds, trust property.
Yep. And then it goes on to say, and will set up, lost, or destroy instruments and records, and will cancel fraudulent deeds. So if they take your note, you sit down at that closing table, whether you're buying a car, whether you're buying a house, okay, and even if they never produce the note, equity will declare, it will make property, and will what? And will set up, lost, or destroyed instruments and records. So whether you have the note or not, we know the trustee took that note and did what they did with it. So equities are going to set up the lost or destroyed instrument.
And we know that because we created the record from it.
That's right. And will cancel fraudulent deeds. So if they did something fraudulent with that note, equity's going to cancel that deed that they did with it and remove the clouds on the title. And will, by injunction, protect the party in his right and restrain a party in his wrong.
Right.
Man, this maxim so applies to when we sit down at a closing table and we give that res for the extinguishment, for the doctrine of NTT of merging titles.
Right.
It's so consistent with and perfectly for what is going on today, as was back in 1907 when Gibson wrote this book. It says, in all the foregoing cases, the common law either take no remedy or else merely allowed for damages for the wrong. Okay? Well, our relief is the extinguishment of the debt. And today, common law or statutes and codes give no remedy for the extinguishment of the debt. And it's no different then than it is now.
Right.
So when I read this, I really see a lot of how this maxim applies once we learn how to proceed into the outlaw side to go ahead and express our rights properly and have the evidence thereof. Do you see anything else in that you wanted to share about that section?
No, I think you kind of covered them all. First thing that jumped out at me, like I said, it was what was used in the Hutchinson Maxims Center case.
All right.
When I read it the first time that I've seen that it was used in that manner.
I got to look in the last maxim we were reading because there was something in there that I was hoping that I was going to be able to get you on to discuss with it. And equity acts upon the person, and this is why they put us in jail. Let me go ahead and see if I can find it. It's in number 32. I'm pretty sure. Obviously it's got to be 32, but let me find out which paragraph it's in. All right. there, Section 32, fine number 4. It's about a quarter of the way down the page on page 26.
General?
Yep, in general, the decrees of the Chancery Court were enforced through the personal act of the party itself. If the party failed to refuse to do what the Chancellor, by his decree, required him to do, compulsory process was issued, but no compulsory process was issued until the party had been served with a mandate commanding him to do what the court required of him. If he then disobeyed, he was adjudged in contempt and was committed to prison until he complied with the orders of the court. If he still refused, his property, real and personal, was sequestered and applied to satisfaction of the decree. Tell me that's any different from any civil or that's today what makes all crimes commercial. They've just applied that in the commercial realm, both in the civil and the commercial court on the outlaw side. Because when they pick you up and they take you to jail, your personal property is being sequestered and applied to the satisfaction of the decree. Isn't that interesting how that's right there in that maxim?
Yes. What I found the most, well, I won't say the most interesting, but one of the things that stuck out to me today when I was reading was the fact of, taking the actual maxim itself, equity acts upon the person. I like the way, instead of empowering the plaintiff to take the law into his or her own hands by giving them the power to say, collect what it was that was due to them, the court of chancery acted directly on the defendant and compelled the defendant by way of a court decree, to act specifically by way of performance, contract, trust, indenture, or whatever the case may be. I just like the way it acted upon the actual defendant himself or herself instead of empowering someone else to do or take the law into their own hands. Like I said, it acts more specifically on the defendant to do what he or she is supposed to do. I kind of like that idea.
And one of the things that particularly take notice of in this section is how by 1501, okay, to read that formal practice Carolina, but in 77, of the mode of carrying section by tax forfeit, attached by proclamation of rebellion, a precedent inadequate legislature of Carolina authorized and decreed as law. And that's right. But the thing that I'm trying to point out here is where it says execute on chancery as at law. And in 1801, the legislature enacted that instead of treating parties to bailiff as the practice act, the court would our right to possess title out of person against free pronounced. So there's only ways that can happen. And that's for the legislature to start requiring everybody to register some record of what it is they are laying. That's the only possible section in that nation. So go back to our history, look at that. And how long, we're only talking about equity because that we had our rights given by nature, God, and nature laws. Well, these guys said the fact that we had rights by God, and nature laws. We had to figure a way around expressing our rights for some. So they do that by creating this title registration. So then they can set the title and they can make people trustees and they do that to that title. So, we did that 212 years now. So when you all go back and look at history, what happened when the legislature started acting as that law, opposed as equity, and then you're going to probably get not too long after that the court itself probably went by the wayside. Why was father when relating to real people, they have the opportunity to put their title to that which says way too low in volume law. So I can't really do much about it. I'm on my cell phone. Turn the volume up. I don't know. Is that any better? Yeah, but I'm talking to you over Skype. That's easy. Whether or not you can hear me over cell phone, I had to call to the conference and giving us all kinds of stuff. You maybe throw motivation. No, not any of that. It's a nice night. It's a lucky conference. Did you hear that much? Help free conferences. Okay. Maybe not. Maybe they start talking about an impersonum as a real relation. Oh, no, that's bad news. Yep, absolutely. We're bad for that. Talking about what's bad I talk about. Well, hopefully this will be better. Scott commercial is unlike. Right. You're coming to my microphone. Problem. I just turned you up to be any better. I have to make sure the microphone, you're loud. Can't hear me? Nope. Way low. Maybe if I went back. Hey, hopefully that'll be a little bit better and everybody can hear Marshall and I a little bit better. Marshall's getting ready to call me back. There he is. Hey, Marshall. Marshall. Uh-oh. Marshall, I'm trying to hear you. All right. Try me again, Marshall. Sorry, everyone, for the technical difficulties this evening. I don't know what it is. I don't know if it's bad weather up north or what, but hopefully things will get better. I'll sure keep trying. Can you hear me now? Am I a little bit louder, everyone? Is that better since I called back in, folks? Okay. Sounds like it's way better. Awesome. Sorry for the technical. Okay, we're good now. Wonderful. Everyone, stand by while I try and get Marshall back on the line. Marshall, hey, our volume's better. They're telling us we're going to be a lot better now. All right. Sometimes I guess our connection isn't so good, but sounds like we're doing much better now. All right. So back to Gibson's book and to section 33 that we were about to go into, or was it 34? No, it was actually 34. Equity back specifically and not by way of compensation. If you got that up, Marshall, you want to read it? All right.
Did we read this one already?
Not 34, we didn't. I don't think so.
Yeah, we did. We did read 34. This is when I was speaking that it was similar to the Hutchins case.
Okay, yeah, you're right. Excuse me. So 35.
Okay, I'll read 35.
All right, go ahead.
Okay. Section 35 Gibson's. When parties are disabled to act, the Chancery Court will act for them. Persons of unsound mind are disabled to act for themselves by nature. Infants are disabled both by nature and by law, and married women are disabled by law alone. As a rule, none of these three classes can of themselves enter into any important contract, especially contracts relative to land. But it is often of great importance to their welfare to convert their property into any form or to expend it for their urgent necessities. And the law would be greatly defective in this important matter if it furnished no remedies for such emergencies. The Chancery Court gives this remedy and has full jurisdiction to do everything necessary for the welfare of persons under disability. People may be asking, this is section 35 of Gibson's book, page 55 of the PDF, actual section 35. When parties are disabled to act, the Chancery Court will act for themselves. So continuing on, the Chancery Court gives this remedy and has full jurisdiction to do everything necessary for the welfare of persons under disability. It may sell, lease, or exchange their lands, convert personalty into realty, or realty into personalty, order the expenditure of any part of the principal of their estates or their education or maintenance, and, in general, do any act indispensable to their welfare. The court at all times having in view the best interests of the parties and acting as would a prudent and considerate parent.
So probably what we really need to do, Marshall, is find what means it's meant by disability. Because people think that might be somebody with crutches or maybe some type of disorder, but I still don't think that's what they really mean in this context. Do you?
Well, I think it could be taken in both ways. I think the more normal mind would take it as a form of disability as far as someone who is disabled or an infant, but I think it would take more of a well-studied mind to know and realize that they would be talking about someone incompetent. Now, you can even break the incompetency down into two sections, whether we're incompetent as far as mentally incompetent by having some sort of a mental illness, or are we incompetent by way of lack of sentient knowledge?
Well, disability in Black's Fourth is defined as the want of legal capability to perform an act.
Well, that would be a child or a married woman, as it's stated here.
Listen to this, and then it says, wow, disability is either general or special.
Really?
Yeah. The former, when it incapacitates the person for performance of all legal acts of a general class, or giving disability is also either personal or absolute. The former, where it attaches to the particular person, and arises out of his status, his state, how he expresses his state, right? Go back to 424 and learn what kind of a state you're holding, folks. Particular person and arises out of his status, his previous act, or his natural or judicial incapacity. The latter, where it originates with a particular person, but also extends to his deep or successors. Wow, so you can only have a legal disability. Others can as well. You're the ones that are your descendants. That's considered with so you can pass on a legal disability. I never thought of that. Consider special reference to the capacity to contract a marriage. Disability is either canonical or civil. A disability of former class makes the marriage voidable only, while the latter, in general, avoids it entirely. However, it has been held that in the absent statute, a court does not have jurisdiction to annul marriage for a canonical disability. Now, canonical was canonical.
I don't know, but I know the admiral side of the court doesn't have jurisdiction. So a marriage, that is an equal action or equal use. That presumption case, it actually listed a whole slew of different causes of action in equity.
Canon, the word canonical, is pertaining to or conformity to the canon of the church. And a canon is a dignitary of the English church. A dignitary of the English church being a prebendary or member of the cathedral chapter. All members of chapters 17 are now entitled canons. A law, and then the next thing under canon is a law, rule, etc. A law, rule, or ordinance general, and of the church in particular. An ecclesiastical law or statute. A rule of doctrine or discipline. The term is generally applied to designate ordinances of councils and decrees of popes. So a pope can give a decree. How about that? So I think that's what we're talking about here when we go to disability. We're talking about canonical is a rule. So let's go back and put that in context. It's considered with reference to the capacity to a contract of marriage disability or either canonical or civil. So a rule by the church or a disability of the former class makes the marriage voidable only, while the latter in general avoids entirely. However, it is held that in the absence of statute, the court does not have jurisdiction to annul a marriage for a canonical disability or a rule of the church. Okay. So now that we know what a disability is, let's go back and look at 35 and understand what that means there in the context here.
Well, in this context, I believe it would be speaking of the incompetency or the inability to make a choice, because as it states here, an infant would not be able to make a choice because it says infants are disabled by nature and by law for obvious reasons. And married women are disabled by law alone because they need their other counterpart, meaning the husband there be able to make a decision in matters of that nature. So a wife will be able to. So I think it's talking about disability in regards to being able to make a choice for oneself.
Right. Somebody who's incompetent. Somebody who's unable to make a choice.
Right. In the context of what it's speaking of in here in Section 35, I think that's more of the line that it's going into.
And let's make sure we point something out here about an infant. We're not just talking about a baby in diapers. We're talking about somebody who's not with knowledge and understanding. Okay. Right. It doesn't matter if somebody's 5 or 50. If you don't have knowledge and understanding, you're disabled in the eyes of the law.
Right.
You're not able to act legally.
You have reached age of majority as yet, absent knowledge required.
Yep. So Chancery is going to act for them when they're disabled. How about it? Very interesting. Very interesting. So, and of course, that's because Chancery or equity is the court of fairness and consciousness. So consciousness has to act for those that are disabled or who are infants.
Right. And 9 times out of 10, an infant is going to more than likely have a beneficial interest. So courts are going to always come in and step. Well, I won't say always, but in most situations, I feel courts will come in, especially in regards to infants or quote-unquote disabled person, and they come in and definitely what is right and just someone who doesn't have the age majority or the administrative abilities to
who aren't disabled. Yeah, right there with you. Hey, Mark, let's do this. Let's open this up for questions and answers because we got through a few of the maxims, and it's already 11:45. And I don't want to go till 1 o'clock that we're reading and talking before we get some people involved. Some people, I guess, might have to go to work in the morning and stuff like that. So before it gets too late, we might be able to have discussion. So if the moderator wouldn't mind opening up for questions and answers. For anybody on the call, it's star 6 to 1 to get in the queue, star 6 then 1 to get in the queue. And then
while Lisa's queuing up the Q&A, I just wanted to go over something real quick to actually reiterate something that CW has been talking to us about for a while now, and he's been speaking of these maxims and how we need to learn the maxims. And I remember when he first started telling us, thinking to myself that that we really just need to know these maxims and we should be okay. Now, there was something that made me think about CW earlier today as I was reading, and it's section 31. Maxims generally considered. Now, there's a very, very, very powerful statement within this paragraph here, but I want to read it again, and I'm going to tell you the part that really jumped out at me. But there are certain grounds. I know I went over this before, Eric, but I just want to, go over it again while we're waiting on people to get into the queue. But it says there are certain great underlying principles, often called maxims. Now, when you go to the footnote, a maxim is so called because its dignity is maximum and its authority the most certain, and because approved as the maxim by all, which we all know maxims need not be proven because they are proof itself. But carrying on, it says called maxims, which are the fruitful sources of a vast number of particular rules concerning both rights and remedy. These principles are a component part of equity jurisprudence. They lie at the foundation of universal justice. It sounds a lot like the phrase that Christian loves, that equity is everything without law, and law is nothing without everything. Law is nothing without equity. So these principles are a component part of equity jurisprudence. They lie at the foundation of universal justice, are the sources of municipal law, and have been worthily and aptly called legum legis, the laws of the laws. But the part that really got to me was this last sentence, basically, where it states, the student, this is the most important part to me, the student who has made these principles a part of his mental habits, who has, as it were, incorporated them into his very intellectual being, has already mastered the essence of equity and has made the acquisition of its particular rules an easy task. And I just wanted to reiterate that because Christian has been telling us this for about 6 months now, that we need to learn these maxims. We need to know the maxims like the back of our hands, and we need to take the time out to learn the 15 to 20 or so maxims that we have, because once we learn them, and we learn them in their true meanings and their true context and the application of them, every situation that we come across, we would be able to see what equitable maxims would apply to those specific situations. Now, with the Gibson's book, it really, really does a great job with breaking down the actual meanings of them and real intent of these maxims. And once again, I just wanted to point that out to people, that if we know the maxims like the back of our hands, like Christian has been telling us, we would find ourselves in a way better off situation when we find ourselves even in the court of law or in the court of equity, because although this book is geared towards equity, there is a lot of principles that are used in the at-law side of the court as far as the pleadings and things are concerned. So we definitely want to have those equitable eyes. And I want to read something else, footnote number 5, and it's quoted from Pomeroy's Equity Jurisprudence, where it says, so vast is the number and variety of suits in chancery that it is impossible for a solicitor to find a precedent for every case, existent if it existed. But he who has the maxim mastered is saved much of the drudgery of hunting precedents. Out of 26 letters of the alphabet, by permutations and combinations are made the countless multitudes of words and sentences written by Earth's millions since writing was invented. So out of a few fundamental maxims, the rules which by proper application will determine the equities of the vast proportion of equitable suits instituted in the chancery. Maxims will take care of everything. 100%. Learn the maxims and you will see how they will apply in every little thing that we do, or every major thing that we do. These maxims will apply, and it is definitely 100% one of the best things that you can do is to study the maxims. Even if you were to take one maxim or two maxims per week, and before the 7 days are over, you need to know, this is something that I'm actually starting to do as of yesterday, whereas I'm going to take two maxims a week, and out of those two maxims, I'm going to go through every equity jurisprudence book that we have that speaks of maxims, and I'm going to study every book in regards to those two maxims. So by the time the end of the week comes and it gets here, I am going to know the maxim like the back of my hand. And I wanted to make sure that I also give the people the differentiation between equitable maxims and not at-law maxims. Sometimes I forget, just because NTT has been going strong for over a year now, we get new people who come in all the time, and sometimes we have to reiterate what we would think is something that is already well known and established. But I'm definitely speaking of equitable maxims. And once we learn these equitable maxims, this is something that I plan on doing like myself. If you can take 5 maxims, that's fine. If you can do 1 maxim a week, that's fine. I personally am going to do 2 because I want to take my time with them and I want to know them like the back of my hands, to where as soon as any real life application comes towards me, I know what maxim applies. Every time I look at a pleading or an at-law action or an equitable action, I know what maxims apply. And I just wanted to take that time out just so people will understand how important the maxims are. Now, the equitable maxims can't be used at law, but at law, they have at-law maxims. Yeah, you would probably want to look those up too. But equity, the maxims in equity only and are specifically for maxims in equity. Sorry, I kind of lost the train of thought just now, but just want to make sure that people understand the differentiation between at-law maxims, equitable maxims, and which venue each applies. So pay attention to the maxims, ladies and gentlemen, as Eric has been going over these maxims over the last, say, 2 months it's been now. Eric?
More than that, my friend, but nevertheless, bottom line is that, Monday night, that's what this is about. And it's probably going to be about this for at least a little while longer, and we're always going to be talking about them, because if we can apply the maxims in everything that we look at, in every bit of Gibbs' book, and every bit of Pomeroy's book, and Bishop's, and all the other authors we can look at, we can figure out why these guys wrote what they wrote, because they knew this stuff from the beginning. There's no reason that we shouldn't be recognizing it as well.
Right. Here's another thing that I want to read of why it is very important to have our trust. Say it again?
I'm good. Go ahead.
Hold on. There's one last thing that I wanted to read before we really get into the Q&A. But still reading in footnote number 5 at the last paragraph, something that I just touched on a little while ago. Now, although we want to be able to differentiate between the at-law maxims and the equitable maxims, and the at-law pleading and an equitable pleading, listen to what this says. The maxims and principles contained in this chapter are not all strictly maxims and principles of equity. Many of them are maxims and principles of the common law. Nevertheless, they have all been adopted into the family of equitable doctrines and are constantly used and applied by our chancery courts. The author has long been convinced that no one can master the jurisprudence of equity who has not thoroughly comprehended equity and its maxims whereby the most difficult problems are readily solved. And so believe no little space has been devoted to them. These principles and maxims constitute a system of jurisprudence based on good reason and good conscience, and are designed to enable the courts of equity to do complete justice between all the parties in any litigation. However novel, abstruse, complicated, or numerous the questions involved may be. I just wanted to read that and give that clarification of the differences between the at-law maxims and the equitable maxims. But if you were to pay attention, especially to what this just said, these equitable maxims can apply in certain suits and situations to a common law action. Clean hands is clean hands, whether you're in equity or whether you're in the outlaw side. Now, correct me if I'm wrong, Eric.
Oh, I agree. One thing that I was just thinking about is they are designed to enable the courts of equity to do complete justice between all the parties, okay, in any litigation, however novel, abstruse, complicated, or numerous the questions involved may be. So what I'm getting at is that complete justice, and I mentioned this a little while ago, complete justice can only be gotten, can only be attained by going through a court of equity. It's impossible to do it on the outlaw side.
Absolutely.
This is the difference between private and personal.
So now here's another question, and this is not even an answer. This is a question that I'm actually posing now. In a pleading or an action that is coming against you, if you were able to, how should I say, apply a maxim for each and every part of the complaint, would you be able to use that as your SOI or your material evidence, because the maxims need no proof? They are proof on its face.
What we're talking about in equity, absolutely. Okay. In the public, you're going to have to give them something tolerable that has the maxim within it.
Right. No, I was just speaking strictly equity.
Oh, in equity, obviously.
Right.
Because we can't bring those precedent cases in the equitable court. There's no reason for that. And plus, we would commingle anyway.
Right. Well, I asked the question because just in case there may be some newer people who are listening in on the calls right now, like I said, sometimes we forget that you have to take certain things back to the basics. And I see Lisa, she's really great with it. Although certain things that she may believe that we all know, she would go back in and revert us back to the beginning and say something like, make sure it's a special court of equity as opposed to an at-law side or something like that, that we would think that people would know, but new people come in every day. So that's why I'm just reiterating that one fact there.
Absolutely. And, hey, for those of us who have been with us for a while, we still need reminders.
Absolutely.
No doubt about it. We still are dealing with conditioning of a lifetime of construment in the outlaw fictional side. And even for us, we have that challenge of getting into that private place where we can issue freeze and have enforcement. So this it's just foundational to us today as it was when we first got into this back on 11/7/09.
Right.
Well, Marshall, it's 12 o'clock. We don't have anybody who's come on the call yet that's come on the queue. And with all the technical challenges I think that we had tonight, I think the challenge is that we probably lost a lot of people to the challenges we have, and they couldn't get on to pre-conferencing.
Right.
So I'll tell you what, why don't we call it a night if nobody's going to come on, and then maybe tomorrow night we can have some opportunity for special BW, and pre-conferencing will be working better, and it'll all be a better situation. I think that sounds pretty good, don't you?
I mean, that sounds fine with me also.
All right, my friend. Well, it's been great talking to you. And I think we were supposed to share the difference between equity and outlaw and special equity. The private, he wants us to explain the difference between equity value and the difference between equity outlaw and the special equity in the private side. And the equity in the private side is the colorful records that point to our rights, but not the actual evidence thereof. It's just that points to it covertly. We can't show any evidence of our rights in the outlaw side, but they would be able to see it anyway. But the only thing they can see in that side is title. Those physical representations. And equity outlaw is going to be things that are going to be equitable principles applied to titles that they can see in the fictional side of the court.
Right, but even with equity at law, the at law equity still is governed under
governed by the value of the case, for example, $50,000.
Exactly.
Okay?
Whereas special equity, private equity, it doesn't deal with value for the people maybe listening. Private equity deals with the actual thing, the res and specie.
Well, that's going to be the value of it, the value of the actual item. Value in the outlaw side is going to be money. The value in the private side is going to be the item or the
interest in the item.
Interest in the item. That's valuable.
Right.
The interest is mine. The interest is my right. That's the value. One side of it's all commercial or commerce, and the other side is all going to be relation, confidence.
Right.
Duty to perform from man to man.
Right. That's right. In personam, acts of in personam.
Acts of personam. Right? And that's perfectly consistent. And isn't it interesting that they did away with that back in 1801? Because they, of course, have been dealing with titles ever since.
Right.
So a while back, Christian and I were talking about Henry S. Maine and about how he implemented a system in India that was a model for the United States. So look him up, learn about what he did, and then look at what year Henry S. Maine came over to the United States and did what he did in order to implement the system here. And then we can see the time where it evolved and see how it evolved, and then we can look at how the United States was as a republic for them. To get an idea how you can actually go back and have a special relation instead of being involved in a contract of commerce. The special equity by relation, that's the get out of the fictional realm. Or not out of it, but understand that that's the other side. You'll never be out of it.
You want to know something? I mean, I don't know how many people on the call right now, but this Gibson's book has taught me something very, very important, and I think it's worth just to say real quick or speak upon for a minute or two, because people may have to do this same thing or follow the same suit within their state. Now, read Gibson's, and this was just today, I found out that when equity was instituted here in North Carolina, words of equity were given specifically to the superior courts here in North Carolina. So when I read it today, because I'm wondering what's going on with North Carolina and Tennessee, and it ends up come to find out that North Carolina used to own all of the land in Tennessee, and there's a whole bunch of strings attached between my state here in North Carolina and Tennessee from where this book is written from Gibson. And the funny thing is, I went and I checked a couple of Supreme Court rulings, and I found one as early as 1989 or 1990, which also stated that the courts of equity were given to the superior courts here in North Carolina. So it made me wonder, Eric, now maybe we could hammer this out in my mind real quick and real fast. It made me wonder, does the equity jurisdiction start, or the ability to invoke an equity jurisdiction, does it start within the superior court here in North Carolina? And the reason why it's kind of fuzzy in my mind is because an injunction is a purely equitable mode of relief. Right. 100%. But within the district courts or the trial courts, which is one level lower than the superior courts, they have the ability to access this equitable action of an injunction. So that would mean that the district court would have an equitable jurisdiction if it's allowed to give injunctions and TROs, which, like I said, are strictly 100% equitable. But the Supreme Court rulings here in North Carolina state that the equity jurisdiction was given to the superior courts.
Wait a minute. You know which equity jurisdiction they're talking about, right?
I would 100% I would like to say they're talking about the actual public equity, but from when I was reading the Gibson's book, this stuff happened from like 18-something, way before statutes and codes and things of that nature. And this is what 1782, as a matter of fact, is when it happened. 1782, long time before 1933, and it's kind of bugging me out. I was going to actually talk to CW about it, But if it's stating that it was given to the superior courts from this treaty or this law from way back then that was passed, and then I read it in a modern 1990 or 89 Supreme Court ruling that states that the equity jurisprudence was given to the superior courts, then that still leaves that question for me. And I think everybody within the states need to actually find out if it's something similar within your respective state that you live in. So if the courts of the district level or the trial court level are able to give injunctions, then let's deal with that. Hold on, let me read section 15, page 37.
Mark, where does equity truly begin? Where does it truly begin?
What do you mean by where does it truly begin?
Where does conscience, where does fairness, where does relation begin?
It begins with the individual, the person.
Right. So you're a minute ago saying, is it with the superior courts or could it be the other courts? Truthfully, it's between you and I right now.
I mean, I understand that, but there's an express provision in two different places that state that the equity jurisdiction was given to the superiors. Now, hold on, let me read the last couple of lines here. This is what I'm being directed to. And in short, those states that have adopted the code practice have, in effect, by statute, substituted the simple and pliable pleadings of chancery for the stiff and cumbrous forms of the common law. And so, although in many of the states there are no separate chancery courts, yet in those very states the pleadings, practice, and principles of chancery are prevalent and well nigh supreme, although to some extent under new names. And in the federal courts, the principles, pleadings, and practice of equity remain wholly unimpaired. So I definitely agree with you, Eric, where I know equity starts with us because we are equity. We're the beginning of it all, but it was just when it comes to the invoking of the actual special equity courts.
Right, and it says right here, those states that have adopted the code practice, okay, statutes and codes, commercial side, okay, those states that have, and we know it's definitely North Carolina and Florida and probably all the rest of them, have in effect by statute substituted the simple and pliable pleadings and chancery stiff and cumbrous forms of common law. So, just because they adopt the code practice, and the Supreme Court was ruling on the code side of things, not on the private side of things, as they say that, this is all in the commercial realm that they gave it to the district court, or to the superior. By right, it's always been there in every court, by right. But the problem is we don't know how to express our records. We don't know how to express our rights through the proper submission of admissible evidence on record. That's the challenge as to why they, for so long now, said that it's not with the district courts, it's with the superior courts. That's why. That's why it's not with your county courts. That's why it's with the state courts, because it's bringing it in. So they're with the code. They're with that's the code, the statutory law. So it's always been there by right. You can't lose it. We always have it. They just hit it, and they're putting it in trust. Two sides of the court, equity versus outlaw. The jurisdiction, two vengeance in one court, one judge, two sons of law.
Right. See, now, but I agree with that. But then, for instance, I've heard CW say before, and I won't actually quote him on this because I don't know the whole entire thing, but I remember him speaking one night a while back as far as, say, like a traffic court is concerned. To get a traffic ticket, do they have a court of equity within this court that you're going to fight the traffic ticket about? And if I'm not mistaken, like I said, maybe he might chime in on the Skype and just say yay or nay, but if I'm not mistaken, I do believe him stating one day that you won't find a court of equity in that regular court that you would go to fight the traffic ticket in. Now, if there is so then that means the court of equity, if invoked properly, is everywhere. Small claims, traffic court, district court, superior court, supreme, appellate, it doesn't make any difference.
And I can tell you that in Florida, that's a fact. It is in every court.
It is in every court.
It's Florida for sure. But this said it's right down to the small claims court in the statute in Florida. Even though that's code, I'm just telling you right now, I read the statute here.
I told you, man, the other day, I want to move to Florida with you guys, man. You guys got some really cool laws over there.
So we're going 34, footnote 34, section 2. Wait, see if I get that right. 34. Yeah, it's just
Footnote 34.
what page is that?
I'm about to tell you this. Footnote 34 is page 57 of the PDF. And it says, footnote 34, Boni Julius S. Lease, well, it's some big long Latin. I don't even know how to pronounce all of it. But it means, it's page 57 of the PDF, footnote 34.
No, Marshall, you're reading the wrong thing. He's saying section, I think, referencing section 282 and 280 through 288. So, 37 in the PDF, section 37. This is confusing. Footnote 34 of 37 PDF, 34 in section 37. Okay, maybe it is.
Oh, and it's telling us to go to 282 to 288. But footnote 34 doesn't say anything.
What page of the PDF? How about that? We'll just go to that page PDF of the PDF. We'll just find the footnote.
Well, the footnote that Christian is referring to is on page 37 of the PDF. But all it does is refer us to sections 282 to 288. So let's go there. 282.
Now I got it. What page is that of the PDF?
282 is page 257 of the PDF.
All right.
282 to 288. Okay, and I have a bookmark. They never bring claims for equitable title on legal. This is not a complete suit, therefore.
Right, that's what I was talking about. They never break. That's why I'm saying that we got to go through equity to do complete justice.
Right. Yeah, you were just talking about this a little earlier.
Yep. Demurrers because the bill is not for the whole matter. Section 282. Demurrers are
action is a demurrer. Demurrer, I believe, that's a motion to dismiss.
That's right. That's right. So motion is dismissed because the bill is not for the whole matter. Motion is dismissed because it's not a proper party. Motion is dismissed because the bill is multifarious. And then 285, I'll do an overall cap on this. Motion is dismissed because of repugnancy. Motion to dismiss because of the pendency of another suit. Motion to dismiss because the complainant's hands are not clean. And motion to dismiss because of lack of plaintiff to be slept on his rights. Well, you know we're talking about his equitable rights. You know that's what we're talking about.
Right. But even on the legal rights, you sleep on that, you won't be able to get it either.
Yeah, well, in a legal right, which is the trustee title, which is just gives us the liability.
Yeah.
So we do
although with the liability, we always think of the trustee as being the person with the liability, which is absolutely true. He has the liability, he also has the duty, but then the trustee also has a very important thing. He has sole right of possession. And we got to also remember that because Christian pointed out a very, very important part to me the other day that I didn't really understand until he explained it to me, to where the trustee can actually bring a claim against the beneficiary for possession. And when he said that, it blew my mind. But when he explained it, I understood. Because the trustee, although the beneficiary has the right to take and is the true equitable owner, unless unless the beneficiary is making a prima facie case to actually take what is his or hers wholly, equitably, and legally. If that's not the case, the trustee has sole possession of it, and therefore will be able to make a case for possession of it. Not possession for him or herself as trustee, but just possession as far as administration of the trust is concerned. And we also would have to start making equitable claims to our legal titles as trustees to hold possession of whatever piece of property we may be wanting to keep.
Right, equity follows the law.
Right. So I just wanted to point that out also, that being a trustee is not always that bad. If you know how to administer the trust, being a trustee can actually be a great thing.
Right, we've been going, that goes back to of things we were trying to figure this best goal kind of thing way back. Christian said, yeah, it's depending on how you know how to do it.
Exactly. If you know what you're doing, you would love to be the trustee if you know what you're doing.
Right.
Trustee has a lot of powers, and even if we all remember Gilbert's book, 70% of Gilbert speaks about the duties and responsibilities of the trustee. Most of that book talks about the trustee.
Right on.
But I guess it all depends on the amount of knowledge you have, whether or not you can administer the trust properly, or whether you just want to make beneficial claims for it. You have to learn both sides of the game. Just like we need to know both public and private, we also need to know equitable benefits and legal benefits. As far as a trust is concerned, and trustee and beneficiary. When I say legal, I don't want everybody to just automatically think at law. We are still talking within a trust.
A lot to think about. A lot to split your brain and make it all pour out, huh?
Absolutely.
For sure. All right. So,
no one's in the queue?
I guess no one's in the queue. That's all right. We've had our challenge this evening. Thank God I got you on, and we got a chance for some discussion.
Right.
So, everybody, read your Maxims. Read your Maxims.
Please read the Maxims.
In every book you can find, read your Maxims. You have a duty to know the Maxims is the proof, and from that you'll be able to build. You'll be able to build everything you need to within utilizing the doctrine of NTT. And hey, and even if you happen to know something, you happen to get your hands on some of the documents that we all produce, all you're going to do is get yourself into trouble without knowing the Maxims and how it all applies. So we're studying consistently, just if you study it all, and become a part of NTT and become a knowledgeable person. Because once you have that, it'll be something nobody can take from.
Right.
All right. So tomorrow night at 10 p.m., we'll be back on the same pin. Our call-in number 712-432-0075. Again, 712-432-0075. But hopefully, pre-conference that'll be working. And next Monday night at 10 o'clock, we'll be discussing Maxims again, and hopefully we'll have other ideas to interweave these Maxims through. So thanks for coming on, the people that did, and you too, Marshall.
I think we're going to call it Maxim Mondays.